So good day everyone, good day sir. I am here to present to you the Criminal Procedure Rules 1110, Rules 1111, Rule 1112, 14, and the Rule 117. Rule 110, Prosecution of Offenses. Section 1. Institution of Criminal Actions. Criminal actions should be instituted as follows. For offenses where a preliminary investigation is required pursuant to Section 1 of the Rule 112, by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. B. For all offenses, by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the Office of the Prosecutor in Manila and other chartered cities, the complaint shall be filed with the Office of the Prosecutor unless otherwise provided in their charters. Section 2. The complaint or information. The complaint or information should be in writing in the name of the people of the Philippines and against all persons who appear to be responsible of the offense involved. So Section 3. Complaint defined. A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer or other public officer charged with the enforcement of the law violated. Section 4. Information defined. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So Section 5. Who must prosecute criminal actions? All criminal actions either commenced by the complaint or by the information shall be prosecuted under the direction and control of the public officer. Section 7. Name of the accused. The complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or is known. If his name cannot be ascertained, he must be described under a fictitious name with a statement that his true name is unknown. Section 8. Designation of offense. The complaint or information shall state the designation of the offense given by the state statute, aver the acts or omissions constituting the offense, and specify its qualifying and aggravating circumstances. Section 11. Date of commission of the offense. It is not necessary to state in the complaint or information the precise date the offense was committed except when it is a material ingredient of the offense. The offense may be alleged to have been committed on date as near as possible to the actual date of it. Section 12. Offended party. The complaint or information must state the name and surname of the person against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known. Section 13. Duplicity of the offense. A complaint or information must charge only one offense, except when the law prescribes a single punishment for various offenses. Section 14. Amendment or substitution. A complaint or information may be amended in substance without leave of the court at any before the accused enters his plea. After the plea and during the trial, a formal amendment may only be made with leave of court and when it can be done without causing prejudice to the rights of the accused. So, Rule 111. Prosecution of civil actions. Section 1. Institution of criminal and civil actions. When a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with the criminal actions unless the offended party waives the civil actions, reserves the right to institute it separately or institutes the civil actions prior to the criminal actions. Section 2. When separate civil action is suspended. After the criminal actions has been commenced, the separate civil actions arising therefrom cannot be instituted until final judgment has been entered in criminal actions. Section 3. When civil actions may proceed independently. In the cases provided in Articles 32, 33, and 34, and 2176 of the Civil Code of the Philippines, the independent civil actions may be brought by the offended party. It shall proceed independently of the criminal actions and shall require only a preponderance of evidence. Section 5. Judgment in civil actions not a bar. A final judgment rendered in civil actions absolving the defendant from civil liability is not a bar to criminal actions against the defendant for the same act or omission subject of the civil action. Section 6. Suspension by reasons of prejudicial questions. A petition for suspension of criminal actions based upon the pendency of prejudicial questions in a civil actions may be filed in the offense of the prosecutor or the court conducting the preliminary investigation. Section 7. Elements of prejudicial questions. The elements of prejudicial action questions are the previously instituted civil actions involved an issue similar or intimately related to issue raised in the subsequent criminal actions. B. Resolution of such issue determines whether or not the criminal actions may be. Rule 112. Preliminary investigation. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Section 2. Officers authorized to conduct preliminary investigation. The following may conduct: First, provincial or city prosecutors and their assistant, national and regional state prosecutor, and other officers as may be authorized by the law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court and their respective territorial jurisdiction. Section 3. Procedure. The preliminary investigation shall be conducted in following manner. Rule 113. Arrest. Section 1. Definition of arrest. Arrest is the taking of a person into custody in order that he may be bound to answer for the questions of an offense. Section 2. Arrest. How made. An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. Section 3. Duty of arresting officer. It shall be the duty of the officer executing the warrant to arrest the accused and deliver him to the nearest police station or jail without unnecessary delay. So Section 4. Execution of warrant. The head of the office to whom the warrant of the arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. Section 5. Arrest without warrant when lawfully. A peace officer or a private persons may, without a warrant, arrest a person. When in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. When an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. Section 6. Time of making arrest. An arrest may be made on the day and at any time or the night. Section 7. Method of arrest by officer by virtue of warrant. When making an arrest by virtue of warrant, the officer shall inform the person to be arrested of the cause of the arrest and the fact that a warrant has been issued for his arrest, except when he flees or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. Section 8. Method of arrest by officer without warrant. When making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and the cause of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flees, or forcibly resists before the officer has opportunity to so inform him. Section 9. Method of arrest by private person. When making an arrest, a private person shall inform the person to be arrested of the intention to arrest him and the cause of the arrest, unless the latter is either engaged in commission of an offense, is pursued immediately after its commission, or has escaped, flees, or forcibly resists before the person making the arrest has opportunity to inform him. Section 10. Officer may summon assistance. An officer making a lawful arrest may more orally summon as many persons as he deems necessary to assist him in effecting the arrest. Section 11. Right of officer to break into building or enclosure. An officer, in order to make an arrest either by virtue of warrant or without a warrant as provided in Section 5, may break into any building or enclosure within the person to be arrested is or is reasonably believed to be, if he is refused admittance thereto, after announcing his authority and purpose. Section 12. Right to break out from building or enclosure. Whenever an officer has entered the building or enclosure in accordance with the preceding section, he may break out therefrom when necessary to liberate himself. Section 13. Arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue or retake him without a warrant at any time and in any place with the Philippines. Rule 114. Bail. Section 1. Bail defined is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, and recognizance. Section